that, I just want to try to put this talk within the context of what Jeffrey brought up this morning, the idea that there are various anomalies in the state's grasp on power and various vulnerabilities to that. One of those vulnerabilities is in the possible disillusionment and possible rebellion of members of the state apparatus themselves when aspects of their belief about how the state works internally come up against the rocks of reality, particularly when they work in the bureaucracies, or in this case with Snowden working for a contractor for the NSA. With the political class in general, it's very important that they not only propagandise the public about the necessity of their actions and the alleged public spiritedness of their actions, but this is also part of a kind of self-education program for the political class within the state apparatus to try to instill in them the idea that this is work that they can be proud of and that they can be happy to do, so that they can attract people into that apparatus. And that means that the state is very concerned with trying to find personnel and make them sufficiently idealistic that they wish to laud the state apparatus as a public-spirited mechanism and join that apparatus, at least if they're talented enough to be invited into that class. They have to simultaneously ensure that their members are not so idealistic that it would upset them too much to discover that the internal workings of the state apparatus do not do the promised things that they were told. And the state generally has to make promises to the public both about outcomes that it will achieve and also about the methods that it will use and the kind of restrictions that it will abide by in order to achieve those outcomes. And on both counts it generally fails. It generally fails to achieve outcomes it has promised, and it also regularly uses methods that it's promised it won't use, or misleads the public about its methods and so on. And for people who go into the state apparatus, particularly at a young age and with a very idealistic view of what they think those agencies achieve, there's a danger to the state that these internal people may become disillusioned, and we've already talked a little bit this morning about a kind of disillusionment process many bureaucrats go through as they've been in the bureaucracy for a period of time. The state needs a method to manage that disillusionment, to make it somehow seem inevitable and to allow their personnel to continue working within that context after having discovered that the agencies they work for do not operate in the way that they'd probably anticipated was the case when they first joined up. And they do this in various ways, one of which is to create channels of diversion for discontent of their own staff, and in particular to create channels for would-be whistleblowers to internally complain to other members within the privileged class about perceived wrongs that are going on in a way that can be managed and never let out to the public at large. And the Snowden case is quite interesting because Snowden certainly was not the first whistleblower inside the NSA to make the kinds of allegations he's made. He's distinguished from previous whistleblowers mostly because he's not even the first, incidentally, to go public. He's distinguished from the previous whistleblowers at the NSA mostly because his revelations involved the public production of a very large number of internal NSA documents that confirmed his claims. Previous whistleblowers had made very similar claims, but weren't backed up by that kind of cachet of evidence. And so where Snowden succeeded, I think, in bringing forward various activities of the NSA and the Five Eyes group to light, where previous leakers had failed, is that he went public with internal classified NSA documents which directly confirmed from the NSA's own material things that they were doing that they had told the public that they had never done. And so part of this talk, I guess, is about that anomaly within the state of them trying to manage their own personnel, trying to keep their own personnel sufficiently loyal to manage any possible disillusionment and rebellion. One very large aspect of that is the punishment of whistleblowers. The state, particularly in this case, wishes to simultaneously tell the public that they're very glad of the new debate over transparency and openness and secrecy and so on, and that they're very glad to have this wonderful opportunity for debate, while simultaneously smearing and attempting to destroy the leaker who made it possible. The reason they want to do those two seemingly contradictory things simultaneously is obviously they want to continue giving the impression that they wish to fix the system and make it perform better, hence the "we're glad to have this debate" kind of talk, while simultaneously making it clear to their internal employees that there are very severe punishments for going outside the state apparatus in their complaints. Now, I'll just see if I can get this working. Wonderful. So before I talk more about the NSA case and about the theory of the kind of moral rights of whistleblowers generally, I just want to give a little bit of a quick talk on the libertarian view of privacy, how privacy and the idea of a possible right to privacy or expectations of privacy fits in with the libertarian view. The reason I do this is that sometimes when you bring this topic up, you'll hear people, libertarians, say there's no such thing as a right to privacy. And in a sense that's true, but in a sense it's also very misleading. So I want to talk about what I think is a legitimate expectation on privacy under libertarian theory. Firstly, culturally, I think many libertarians have a view that runs through the movement that there are a lot of things other people do that are none of our business. And that's a cultural value, I think, that libertarians share, which undergirds a lot of their more specific views on property rights. But that in itself is a kind of recognition of a respect of privacy. And there's a quote by Ayn Rand who says, "Civilization is the progress towards a society of privacy. The savage's whole existence is public, ruled by the laws of his tribe. Civilization is the process of setting man free from men." And so the idea I think she's trying to communicate in this quote, which is from one of her books For the New Intellectual, is the idea that non-intervention and non-coercion is mixed up in the idea of a respect for the privacy of some of other people's concerns. And so culturally, libertarians do tend to be people that are quite respectful of other people's privacy. It's certainly not a necessity, but it tends to be the case. Part of this is because the libertarian worldview is characterised by a high degree of individualism. And when I say individualism, I mean a great deal of respect for the idea that, generally speaking, people are capable of making good individual judgments. Not always and on every issue, but libertarians generally believe that people have the capacity to judge their interests fairly well and usually better than third parties. They have the capacity to engage in mutually beneficial transactions and to judge properly what is in their interest and what is not in their interest. And they have capacities that follow on from that. So they're generally reasonably good at judging their own interests. In terms of, I suppose, actual rights-based entitlements to privacy, these entitlements under the libertarian worldview are judged relative to property rights and non-aggression. So it can be a little misleading when libertarians say, for example, there's no such thing as the right to privacy. It's certainly true that there is no standalone right to privacy that stands above or separate to ordinary property rights considerations, but there certainly are ways in which property rights, entitlements and the theory of non-aggression have implications for what privacy you can reasonably expect. And in that sense, I think arguably you can say there's a kind of right to privacy in the same way that some people say there's a right to bear arms, even though that again is perhaps just a manifestation of property rights. So privacy can be regarded simultaneously as a good cultural value that runs through a lot of libertarian thought, and also as something that is manifested in certain property rights entitlements. And what I have in mind, I suppose, particularly in terms of entitlement, is that libertarians believe that a person owns their own body and therefore has an entitlement to bodily integrity. And generally speaking, we understand that a person has the right to their bodily integrity and the integrity of items on their person, like their clothing and so on, and that this can be dealt with properly by property and contract rights. So there's assumptions that bodily integrity and ownership of possessions unless there's some agreement to the contrary. So, for example, a person could not be searched without their consent if they haven't committed a crime. And so libertarians will at least sometimes take the view that if a person is searched without their consent and there's no crime justifying that search, then that search may constitute an aggression in terms of interfering with a person's body. More broadly, with outside communications, these can again be dealt with to a large extent by contract and property rights. For example, we often communicate in ways where, say through phone lines and things like this, where there's a carriage of our communication by a third party, and in that case a lot of the expectations of privacy are governed by either what's been explicitly agreed contractually or sometimes what is implicitly obvious from social convention in those kinds of contracts. And again, we, as a consequence of this, we generally believe that if a person's communications are monitored without their consent, with no crime justifying the examination of their communications, then that again may constitute an aggression this time against property, perhaps in a sealed envelope being put through the post, or a breach of contractual rights, say with a telephone communications provider or something else. So libertarians recognise contractual rights to privacy. They recognise that expectations of privacy can arise legitimately from contracts. That can occur, as I said, either explicitly or quite often it's implicit, simply in the fact that certain social conventions apply to a lot of communications, and often there are implicit contractual terms as a result of that. Libertarians also generally believe that there ought to be constraints on investigation agencies. Now, depending on your particular view of the state, whether you believe that it should be abolished entirely or whether you believe that it could remain but in some allegedly constrained form, people's views here differ. But I think most libertarians recognise that investigation agencies, if they're to avoid aggressing against people through unnecessary bodily searches or searches of communications, they ought to impose some constraints on the kinds of searches and surveillance they do to try to avoid false positives and try to avoid those kinds of cases. And one in particular, one very well-known constraint, is the idea that an investigation agency ought to have probable cause for a search, meaning that if an investigation agency suspects a person of a crime, generally speaking, they ought to gather some kind of evidence to justify that suspicion prior to an invasive search of the person. Now, if you take a very strict view of that, for example, a Rothbardian view, he takes the view that ultimately whether or not you've done the right thing depends on whether you're right and the person did commit a crime. If the person committed a crime, then you can search them. If not, you can't. And if you did, well, then you aggressed against them and should compensate them. And whether you agree with that particular view or a view close to that, there is, I think, running through libertarianism, at least in regards to privacy and searches, the idea that probable cause, the requirement for probable cause is a good constraint to impose on an investigating agency. Probably the most famous example of this constraint, although not applicable in Australia, is the US constitutional amendment, the Fourth Amendment, which is, well, supposed to constrain the US government against making searches of people without probable cause, and is supposed to also constrain them to only make searches under conditions where warrants are issued on certain terms. So this is an example of at least an alleged or would-be constraint supposedly tying this investigation agency to a probable cause-based requirement for search. This leads on to talking about the ethics of whistleblowing. One of the reasons the Snowden case is very interesting is Snowden actually, in this case, is doing a kind of thing that is very similar to what the state does itself, and in particular to what the NSA does itself. The NSA investigates and looks for wrongdoing by searching people, by surveilling people, by trying to dig up their secrets. And in fact, that is what Snowden was doing to the NSA, to try and dig up its secrets, to demonstrate its wrongdoing. And the reason that that's important is that it brings to light more clearly in this particular case the particular hypocrisies of the state in dealing with this. Those kinds of hypocrisies are often evident anyway, but the Snowden case, I think they're more evident by virtue of the fact that Snowden's activities were in some senses very similar to the NSA's own activities, and so we can see a lot of the double standards being applied there in how the government treats the NSA's activities versus Snowden's activities and so on. So I want to talk then a little bit about the ethics of whistleblowing. There have been various arguments made for why Edward Snowden is a traitor and a terrible criminal and ought to be prosecuted or, in some cases, simply executed, depending on which wonderful media commentators you listen to. So it's very important to examine the moral status of his actions because he does come under a very savage critique from defenders of the state, and because the fate of the actual whistleblower is a very big part of the government's attempt to manage the rebellion and disillusionment of its own personnel. So although Snowden is not the story is the leaks and the actions of the NSA, it isn't inconsequential what actually happens to this guy, if he's executed or if he's arrested or whatever ends up happening to him. There are various arguments for why Snowden has done the wrong thing. One of them is that he stole information that wasn't his. He stole information that belonged to the US government, and so he's a thief, and we should be upset with that. Another allegation is that he breached a contractual confidentiality agreement, which no doubt he had some kind of agreement with the agency he worked for, that he agreed that he would not divulge classified information and so on. And he certainly has done that. And then finally there's the accusation that he has disobeyed the orders of the state by disobeying their classification rules. So I wanted to look at those three things, and also more generally at what kind of ethical basis a whistleblower either has or doesn't have to take those kinds of actions. Now, first of all, whistleblowers are often subject to contractual obligations to their employers requiring them to keep information private, and certainly in the Snowden case he would have been. He worked for a contractor for the NSA, and no doubt that would have involved some explicit guarantee by him that he not divulge classified information. And this is particularly the case when you're dealing with military and intelligence agencies, that these kinds of agreements always apply when they're talking about sensitive information. So certainly Snowden has done what he's accused of there. He has breached a confidentiality assurance that he gave, either directly to the NSA or to a contractor of the NSA. But when we examine the moral status of this and the legal status of that kind of contractual assurance, we see that it's quite dubious. Generally speaking, contractual agreements are often a legitimate part of many businesses. Confidentiality assurances can be required for an operation to run successfully, and generally we are quite respectful of that. But there is also a general principle in law that the law does not recognise the validity of what are called unlawful contracts. And this includes contracts which are either directly for an unlawful action or to kind of hide the committing of an unlawful action. So an archetypal case of that would be that although courts, at least courts that function properly, would recognise property rights and hold people to their contracts, they wouldn't, for example, hold a person to their contract to hire a hitman. If a person hired a hitman, say, and then the hitman killed the target and they refused to pay, the hitman would not be able to sue them in a court and say, look, this guy made me a contractual promise, I've done my job, he needs to follow through. Aside from obviously incriminating himself for murder, the courts don't recognise that. They say that this is an unlawful contract, a contract for an unlawful purpose, and therefore the contract itself is void, and we will not enforce payment of that. I don't recommend, by the way, stiffing a hitman on his money. You've probably got bigger problems if that happens than being sued. And here's a quote from a case called McMullen and Hoffman, where the court talks about this idea of unlawful contracts. And the judge, Justice Peckham, says, to refuse to grant either party to an illegal contract judicial aid tends strongly towards reducing the number of such transactions to a minimum. So the courts have recognised that not only philosophically is it invalid to enforce an unlawful contract because it breaches the very property rights that are supposedly underlying the idea of contract, but also it has good policy implications in the sense that parties entering into unlawful contracts know that they then do not have the protection of the legal system to enforce those contracts. Now, what this means for whistleblowers is that whistleblowers are not lawbreakers by virtue of having broken contractual confidentiality assurances. If they expose criminal dealings and these kinds of things, a confidentiality assurance where they have promised not to disclose secret information does not bind them morally to keeping that information secret. Now, certainly the legal system doesn't always operate that way, and so in a positive law sense, certainly I don't think Snowden would succeed with that argument in court. But if one does apply the idea of unlawful contracts to that field and thinks of it in a natural law sense, it makes sense to believe that whistleblowers are not lawbreakers by that standard, even if they do indeed break contracts in the course of divulging criminal dealings. The next thing that Snowden is accused of, aside from simply breaking his word, is that he's divulged classified information and that this is bad. There's a law professor in the US called Jeff Stone who basically came out and wrote an op-ed condemning Snowden's actions, saying that the state can legitimately classify things and you shouldn't reveal them once those things are classified. And he seemed to be saying that the state does have restrictions on what it can stop you doing. It should be constrained, but this is something that it should be allowed to do. This is the exception to the rule, that the state can classify information as secret and you shouldn't reveal classified information. The reason that that's not a very persuasive argument is that it essentially becomes the exception that swallows the rule, because the state of a bit of information being classified is determined by the government itself. And so to say that a piece of information is classified simply means that whatever agents of the state are in charge of that have decided that it ought to be kept secret. So to say, sure, you can reveal the government's secrets unless they're classified, is essentially saying you can reveal the government's secrets unless they say you shouldn't reveal these secrets. So it becomes the exception that swallows the rule, that if you take that view that this self-imposed classification overrides the general right to divulge these secrets, then that becomes something totally in charge, totally within the state's power. They can arbitrarily decide what's classified and what's not. And in particular, when we look at the history of military and intelligence affairs, and particularly scandals such as the present NSA scandal and many previous ones, we see that classified status is often used as a means by the state to prevent the public learning knowledge of its own wrongdoing and to prevent embarrassing material from leaking out. Many times we're told that the classified status is necessary to protect national security and things like this. Quite often you find, when you look at the kinds of documents that have been classified but have leaked out anyway, that in fact there's no real national security issue. The issue is that the contents embarrass the state apparatus by demonstrating that they've been engaged in wrongdoing. Okay, so the third line of argument against Snowden is this idea that he stole things that don't belong to him. He stole information from the NSA. To steal something, the person you're stealing from has to own it legitimately first. And this is probably the sticking point with this kind of argument. There's also another sticking point with this argument. So let's suppose, just putting aside that consideration for the moment, that the government does legitimately own that property. There's a general rule, I suppose, in police affairs and so on, and in investigation more generally, that a property owner cannot claim their ownership of a piece of property to prevent confiscation of that property for the purpose of using it as evidence of a crime. For example, a murderer stabs someone to death with their own knife that they own. They cannot then complain that the police confiscate that knife and put it in an evidence lockup. And when they're interviewed, it's put in front of them in a little plastic bag and it's got their fingerprints on them. There's a general idea that their property right claim in that knife is not so strong as to override the capacity of the police to confiscate that knife for the purpose of using it as evidence of their own crime. Because their own crime, assuming they have committed it, vitiates their protection of that property. And of course, if they're found not to have committed a crime afterwards and their property's been confiscated, libertarians would agree that they ought to be compensated for that confiscation of property where there was no underlying crime. But if there was a crime, they can hardly complain of their property being confiscated as evidence of that crime. Aside from that, there's of course the issue from libertarians' perspective that the government doesn't have any legitimate ownership claims to begin with over any of its assets, I suppose, since they're all acquired through taxation, through the proceeds of theft, and therefore over any kinds of documents and secret information in their archives also. And therefore, if they have no legitimate ownership claim over that property to begin with, then they can hardly make a legitimate claim of theft of that property from them. Exactly who that property ought to be owned by is a complicated question, but fortunately one I don't have to pursue here, so I'm going to sidestep that. So information in government documents also frequently comes from unlawful surveillance or forced reporting requirements. So even aside from the fact that all of their property comes from the proceeds of theft, the specific information in a lot of military and intelligence documents frequently, as has been exposed by the leaks, comes from unlawful surveillance itself. So it's doubly damned in that sense. Now, suppose that you're not a raving lunatic libertarian like myself. Which slide am I on? Sorry. You might believe then that, okay, there is some role for government and they do own some of their property. And even if you take that view, generally speaking, people who advance this view that the state is legitimate and does legitimately own property try to bolster this by some kind of reference to their accountability to the public, that they can do these things because they're in the public interest and they're servants of the people and that they're accountable to the public. And that assertion then comes up against, at least in the NSA case, even if one accepts that the government can legitimately own property then, it would be very dubious to say that the government can use that ownership claim to hide their own misconduct from the public if the justification for the state existing and having that ownership claim is that they're accountable to the public. So I think when we're talking about something like the NSA leaks, where the leaks clearly demonstrate ways in which the agency has broken the law and done things which it has assured the public it would not do and so on, even if one takes a view that the state is legitimate and that democracy is okay and justifies the existence of the state, that probably would not protect that kind of use of property anyway. On the ownership of evidence question, it's quite interesting. Usually a person who has committed a crime will attempt to avoid linking themselves to the property that serves as evidence for their own crime. So the murderer who's stabbed someone to death, when he's confronted with the knife in the plastic bag in the police interview room and he's told there's a partial print and they think it's his and they saw his knife block at home is missing a knife that would be approximately this large, admit it, this is your knife, you killed her, you bastard. They'll say, look, that's not my knife, I've never seen it before, I swear, if it looks like one that I owned, fine, but that's not my knife. It's not. They would be at pains to try to separate themselves from ownership of that property. The state really has no such compunctions. The state, when confronted with an equivalent situation, says, "How dare you take my blood-soaked knife? That belongs to me." And in the NSA case, there has, of course, been no attempt to deny that the documents are legitimate. Obviously, they've made the calculated decision that that denial would not work, and so they've fallen back on, "How dare you take our secret documents?" These secret documents that demonstrate unequivocally very large amounts of wrongdoing. How dare you take our property which serves as evidence of our wrongdoing? Of course, they don't put it like that, but that's essentially the kind of claim they're making. They're no different than the guy who goes into the police interview room accused of murder and says, "How dare you take my blood-soaked knife? That's my blood-soaked knife. You have no right to take it from me." So what does this mean for the libertarian view of how whistleblowers can operate within the state apparatus? I said at the start that this is an important kind of, well, at least one kind of anomaly within the state apparatus, that there is always a danger to them that because they make promises they can't keep, both in terms of methods and outcomes, that their own personnel can become disillusioned and rebel against that apparatus by leaking out information on what they're actually doing, and that they rely very much on secrecy. The libertarian framework of property rights allows us to see that there is a moral basis for whistleblowers to operate, notwithstanding confidentiality contracts and things of that nature, and they can operate and still operate effectively either within government or within a private sphere using those kinds of capacities. I just want to give you another example linking the way the government investigates alleged wrongdoings with the way in which a whistleblower such as Snowden investigates the government's own wrongdoing. For those of you who have seen the movie Donnie Brasco, it's about a guy called an FBI agent called Joseph Pistone, who infiltrated one of the crime families within the mafia in the 80s, perhaps. I can't remember exactly when. Anyway, he infiltrated the mafia and managed to rise quite high, even to the point of, I think, being actually made a member of the mafia when he was actually an undercover agent. It's a very good movie, by the way. It's called Donnie Brasco. Donnie Brasco was his fake name undercover. And, of course, in order to do this, to infiltrate the mafia, he had to obviously make a lot of assurances to these other criminals that he was going to keep their secrets and that he would comply with the law of omerta and all of this kind of thing. Now, when it then comes time for the FBI to descend upon this crime family and use this guy's evidence against them, at no point would anyone ever think to say, hang on, he made confidentiality assurances to them. He promised them he wouldn't divulge their secrets. Therefore, we really ought to be holding this guy at his word, and those things ought not be used against the mafia in order to capture them and prosecute them. We understand that in that context, that assurance of confidentiality, it is legitimate to make that false assurance of confidentiality in the course of investigating a crime which has actually occurred, and to deceive and give false assurances in that context. Well, Edward Snowden did pretty much exactly the same thing, and in fact, if you read some of his interviews, he talks about the fact that even at the time he joined this one agency that he was contracting with, he already at that time had some idea that he would be attempting to harvest NSA documents for the purpose of future release. By that point, he was already quite disillusioned with the NSA, who he'd previously worked for. So, some of the kind of moral charges against Snowden, that he was duplicitous, that he made these confidentiality assurances to the NSA, that he promised that he would keep their information secret and then he broke his word, that is all certainly true. But just as with Joseph Pistone, the FBI agent, those kinds of actions are a legitimate part of investigating a criminal agency and investigating the wrongdoing of that agency. And if that investigation requires that false assurances of confidentiality are given, then that is a legitimate part of that investigation. Now, obviously, again, if it turned out that there was no crime, no wrongdoing, and someone's broken their assurances of confidentiality, libertarians will generally tend to say that, okay, they ought to be able to get some relief for the broken assurance. But if there was actual wrongdoing, if the person is right, then the underlying crime means that the agency committing that crime has no defence in terms of those confidentiality requirements. So how does a libertarian approach solve all of this? So I'm going to present, I suppose, what I think is the libertarian solution to this kind of situation. Under libertarianism, the basic legal principles are all derived from the ideas of respecting property rights and therefore respecting contractual agreements built on legitimate property rights. However, obviously, as I've said, any contract restricting disclosure of evidence of criminal acts would be invalid. It would be regarded as an unlawful contract. And therefore, it would be legitimate to breach would-be contracts of that kind in the course of disclosing criminal wrongdoing. So, generally speaking, contractual assurances of privacy would be respected and they would be binding and actionable, but not in cases where the breach of privacy involved demonstrating some criminal wrongdoing. The rule of law would operate in the sense that agencies would be required to operate within the law, and they would also be required to operate in the same way as private citizens. In the case of Edward Snowden, we can see that there's a vast difference between how he is treated and how the FBI agent who infiltrated the mafia is treated. The rule of law tells us that everyone ought to be following the same law, and the same kind of law ought to be binding on everyone. And so there ought not be these disparities. If Joseph Pistone's infiltration of the mafia was okay, then surely Edward Snowden's infiltration of the NSA is also okay. Part of this also means that when an agency such as the NSA is demonstrated to have broken the law, this should actually be regarded as a big deal. One of the things that's quite fascinating about the NSA case is, although initially saying that they have never breached the law and that this stuff is all legal, it's come out in later documents that they obviously have breached the law in many cases. And the government has repeatedly described this as compliance problems. When you or I breach the law, we call them crimes. When the government breaches the law, they're called compliance problems. And in fact, the NSA has gone further than that and essentially said, well, in an operation this complex, there are bound to be compliance problems, and therefore you just simply cannot run an agency the way we run it without compliance problems, and therefore you're going to have to get used to the fact that we're going to break the law quite a bit, in the sense that sometimes warrants won't be complied with, sometimes we will surveil people when it's illegal, etc. Now, that is essentially an admission that your operation can't be made legal. That should be regarded as a big deal, that if you cannot operate within the law in a way that you're doing now, then the way you're doing it now is no good. But somehow that seems to escape people. Probable cause for searches. I said at the start that libertarians generally like the idea that an investigating agency ought to have constraints in terms of how they justify their own searches and surveillance. Obviously, the fact that there was a crime in the end is a justification in itself, but in order to try and avoid false positives, many agencies will try to impose constraints like the probable cause requirement. So I think the probable cause requirement is probably one that would be adopted by private firms, private investigative firms under a libertarian system, simply because if they're liable for damages for, say, unjustified searches, they'll want to minimise that occurring, and therefore they'll want to ensure that there is a good basis for their searches so that they don't get too many false positives. What we tend to get with a state monopoly situation is that because agents of the state don't pay any penalty for searches which turn out to reveal no crime, their interest and their incentive is to always lower the bar on what's required for searches because they pay no penalty for false positives. So having a libertarian legal system where property rights are respected and people can seek compensation for these things immediately imposes an incentive on whatever investigating agency, whether government or private, to adopt procedures, whatever they may be, that will avoid false positive searches. All right. Finally, with respect to the way the NSA operates itself, one of the main things, I suppose, that's been revealed by the NSA leaks is just the enormous degree to which the NSA and the Five Eyes group in general engage in mass indiscriminate surveillance, contrary to the entire idea of targeted warrant-based surveillance. The NSA get a kind of warrant, which I can talk about in question period if anyone's interested, but it's very different to the kind of warrant that a police officer gets to investigate a crime, say. One of the consequences of this is that because the NSA is indiscriminately harvesting data, they need enormous data centres to hold this. And for anyone that's been following this, they've recently opened up a very massive data centre in Utah, which, as far as I'm aware, holds more data than any other place in the world previously built. I think it's estimated to hold, gosh, I'm trying to do this from memory now, I think it's 3 billion megabytes, no, sorry, 3 billion gigabytes or something of that order. A very large amount of information anyway. Under the libertarian view, if an investigation agency is going to operate in a legitimate way and their surveillance is going to be targeted towards genuine criminal suspects based on probable cause, there is no need for infrastructure of this kind. The only possible use of infrastructure of that kind is for mass indiscriminate surveillance. And so I think one of the big things that's come out of the NSA leaks, and one of the things that libertarians ought to be pushing, is the idea that these kinds of massive data centres ought not exist. That's really a technological constraint on the way the state operates, and it's probably really the only constraint they have left, is that they at the moment simply cannot store as much data as they'd like. So that's something that I think ought not exist, that an agency like the NSA ought not build or have data centres of this kind, simply because their only possible use is to breach those kinds of assurances and engage in mass indiscriminate surveillance. Finally, under a libertarian system, there would obviously be a decentralisation of power, in the sense that there would be a decentralisation of the communications firms and so on. There would be several different competing communications firms giving different assurances of privacy, and customers would be free to search around for what they regarded as best. There would be no one overarching agency that owns the internet or that attempts to own the internet. The main effects of imposing libertarian principles, as I see them, is that surveillance would need to be targeted rather than indiscriminate in order to avoid false positives and in order to avoid exposing an agency to liability for invasions of people's privacy. There would be penalties for agencies breaching assurances of confidentiality, and therefore they would have an incentive to minimise that. And finally, investigation agencies would want to operate based on probable cause as a result of that. That's all I really had to say in this session, but I'm happy to take questions. Actually, sorry. I should just say that I'm also going to be speaking tomorrow on a different topic, which will also talk about law enforcement, but a different aspect of that. Now, some people had questions, I think.
Hello. Would, for instance, hacking communications be allowed in a libertarian world?
I wouldn't think so under ordinary circumstances, in the sense that it would probably be governed by contractual mechanisms within the communications firms. And I suspect it would be difficult to hack things in a way which didn't breach contractual assurances, probably, if the system was set up well.
Hacking by a third party to the contractual party.
Sure.
And without invasion, without trespass.
Yeah, well, I would think, I think it depends a lot, the answer, on how a system is set up. I think there is an incentive on communications providers to not be hacked, and therefore it would be in their interest to set up a legal structure and a contractual structure such that it is difficult for third parties to access the network at all without giving some assurances of how they're going to conduct themselves while within that network. And I suspect it would be possible to set things up in that way, such that if a third party hacked communications, they would probably only be able to do so through through the use of someone's property while violating contractual terms they've agreed to. Now, it's not impossible that they might be able to get around that. I think that's probably a difficult area for just interface of law versus technology, but I would think it would be possible to set that up in that way. For example, now if I have an internet provider, say, and if I go on the internet, I agree to certain kinds of ways in which I'll conduct myself through my internet provider. Now, it may be that internet providers get together and come up with non-hacking rules and say, you know, if you're going to work through our service provider, you agree that you won't try and hack other people's networks and things like that. So I think there's scope for at least legally saying this is bad. Whether or not you catch people is an enforcement separate question.
I've got an interesting comment. I run an ISP,
yep.
And we do that. A lot of people will submit reports to us to say we've had hacking activities from your IP space, and we will actively block and stop that. Customers don't really know about it, but it is something that we do just as a matter of principle, because we don't want that stuff occurring in our network.
Yep.
My question was just in relation to if you know of a government body or a body in Australia that attempts to prevent misuse of power. We've got an example where the Attorney General requires us to submit an interception capabilities plan every year, which is essentially our ability to spy on our customers. Like, we have to prove that we can. Once we prove this by a demonstration of network topology and a whole bunch of other things, police and law enforcement then contact us to require us to spy.
Yeah.
And this happens a lot. And I've read the Act, and it says we have to have a warrant. Cops try it on all the time. They ring us up, they send us letters. We never act upon their requests. Obviously, their requests are illegitimate. Do you know of anybody that we can actually report them to? What are we going to do? Ring the cops?
Right here. I think this is the body you report them to here. But our enforcement powers is a little weaker than perhaps the Australian Federal Police. So you're probably out of luck reporting the criminal wrongdoing of the Australian government. Look, the point you make, though, does lead on to the difficulty that a lot of private or quasi-private companies in this area are in, that on the one hand they make contractual assurances to their customers, and on the other hand they have law enforcement requiring certain things of them and using the state's legal power to enforce that. In the NSA case, that's very evident that many communication firms were strong-armed by the national security apparatus in the US into giving over customer data. Now, what many of the communications firms have done is simply to make the contractual assurance to their customers that we will keep your stuff private, except as required by law, as a kind of blanket, all-encompassing exception to the rule. And then, of course, the state, whether or not its actions are legal, certainly argues that they're legal, and the companies that engage with them kind of grab onto those arguments and say, well, we had to comply. Now, certainly, you know, there are companies, for example, like AT&T, I think, has been in a quite long-running relationship with the NSA, I think since the 1980s. But a lot of those communications firms are in a bind. Some of them are culpable to a large degree. Some of them are probably completely innocent in the sense of being bullied around into it. It's difficult to judge that from the outside. But I guess that's the nature of this kind of system that there tends to be, over time, a convergence of the government with large corporate firms who they try and get their work done through.
I've just got 2 points to raise. Firstly, with the analogy that you made with the mafia case, I just think there's a pretty important distinction that you missed, was that with the mafia they're trying to conceal criminality. That's what the disputed sort of evidence is over. But with the NSA, they're trying to conceal information which there was reportedly used to prevent terrorist attacks and things which could be in the public interest. And then going on from that, how would you justify protecting this private information to people who may have been rescued by the intelligence that the NSA gathered through this the spying? Because I know several terrorist attacks were prevented by, especially in New York.
I'm not so confident that terrorist attacks were prevented, but I'll take your first question first. Sorry, can you just remind me what the first question was? The distinguishment between the mafia and the case of the NSA. Well, just to give the audience in general, I guess, a little bit more information of what the NSA actually has done and the legal things applying to them. I certainly think the NSA, unequivocally, without a doubt, committed a crime. I don't think it's sensibly arguable that they didn't, based on the evidence that they did. So I don't think it's an area of distinction with the mafia. Certainly it's a crime of a different nature, but I don't think there's a strong argument that they haven't committed a crime. Even by, not so much against natural law and libertarian theory, but even by the standards of US law. Obviously, the Fourth Amendment, which I showed before, is quite clear in the fact that the government is not allowed to engage in search and seizure without probable cause and without a warrant issued specifying the specifics of what they're going to search. I'll just read it out again. The right to the people to be secure in their persons, houses, papers and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. I think in the first place the NSA's actions have certainly violated that restriction, which means, in my view, that it's unconstitutional and therefore illegal. Even judged against the standards of the Patriot Act, which it operates on, the relevant section of the Patriot Act under which they make these searches requires them to submit applications for warrants to the Foreign Intelligence Surveillance Court. And these are supposed to these submissions are supposed to demonstrate how the information they are collecting relates to is relevant to a terrorist investigation, essentially. And what the NSA have done, they've done a few things. They've essentially harvested masses of data indiscriminately, and when called on this, they've said, firstly, it doesn't count as collecting it if we haven't yet looked at it. So what they say is that when they intercept all of this information and put it in their databases, that is not collection. It's only then collection if they go through and read it. And since most of it goes unread, collection is not collection, according to them. And so they haven't breached that. That's one of the arguments they've made, which I think is clearly false. The second thing, well, some of it is a little unknown because the judgments of the court in these warrant cases are not made public. These are secret court proceedings. But from what can be gathered, certainly they have not complied with the requirement that they demonstrate that all the information that they're collecting is relevant to a terrorist investigation, because there are unequivocal cases where they're just collecting masses and masses of information. The other thing that they've said, for example, is, don't worry, although we put the information in a database, we're not collecting it because we haven't read it yet. And when we read it, we only read it if we have a good justification. So you can rest assured that we only read it if we have cause to believe it's linked to a terrorist investigation or something like that. In some of the NSA internal documents that have been released, it shows examples of queries in their training manuals that they use, and one is, for example, show me all encrypted Word documents in Iran. That's how targeted this is. I mean, So again, clearly the assurance they're giving there is false. And so I think either judged by the standard of the Fourth Amendment or judged even by the requirements of the Patriot Act, which I think themselves violate the Fourth Amendment, in either case they have not complied with those things. And so I would argue that what they are doing is most certainly illegal. Certainly there will be no consequence for that, but it is, I think, definitely illegal what they've done. So I guess I disagree that there's a relevant distinction there with the mafia. Certainly it's a different kind of crime, but I think they're still committing crime. You had a second question which I've forgotten now in answering the first.
I was just saying in terms of probable cause, like there's potentially thousands of people that have been saved.
Yeah.
Chucks that have been murdered. Are you suggesting that protecting these individual rights of information is worth all these lives that may have been saved?
Well, I guess two things I'd say about that. One, I suppose, is that you have to make a decision, I guess, of whether you think a monopoly state is a good protector of people's lives and so on. And so I think, I would, personally at least, I don't think that the government is a good protector of those things, and I think those kinds of services could be supplied better elsewhere. But even setting that aside, the kinds of things you're talking about can presumably be accomplished by only looking at potential terrorist targets. What's really come out of the NSA leaks is the fact that this is indiscriminate surveillance. So even judged by the objective you're talking about, I don't think there is any necessity for indiscriminate surveillance of the kind that's been occurring. The only purpose, in my view, of that kind of indiscriminate surveillance is to obtain greater control over the population. Now, one of the things I suppose law enforcement people have tried to argue is to say, well, sometimes it can be useful because we collect everything, and then when we find out someone's a suspect, now we can go back through information from the past, however long we've stored it, and we can find out stuff that we wouldn't otherwise have known if we'd had to get a warrant now and start collecting now. And certainly that's true. They probably can't get some information they could have that way, but I think that kind of objection is essentially an objection to any kind of warrant-based system at all. So I would say it's probably a dangerous view to have that law enforcement requires indiscriminate, unrestricted search and seizure power, is what I would say. That I think law enforcement can be conducted perfectly well without that kind of indiscriminate power.
Just one more question.
Yes.
Hi. First of all, the whole concept of whistleblower is not even a valid concept really anymore. I think it's outdated because, for a start, the whole notion of whistleblower is related to people who believe that there is a right and a wrong, and therefore the people who are in the wrong are telling on the other people. Now, for a start, if you take a look at well, you can take a look at anything like America. They are above and beyond the law in war crimes in relation to the International Criminal Court. You take a look at the biggest standing army in the world, which is Eric Prince and Blackwater. He has such a huge army. I was just researching this recently. They are totally above and beyond the law. They can't, they can do anything they like. They can go and do hits on people and corporations and anything, and there's no law against that because they're above and beyond governments. The whole notion of whistleblower is obsolete from the point of view that those people who want to believe that their government is there looking after them, with all due respect to the earlier question there, is very naive in thinking that the government is out for our own interests. That is not necessarily the case. Sometimes it is, and often it's not the case. They might be, they might have the interests of corporations as opposed to people as their main target for their interests, and therefore things like terrorism and surveillance are going to be skewed to the information they collect in relation to however they want to operate their nefarious business operations throughout the world. So in relation to the fact that there are all these shadow things operating, like shadow armies and shadow governments, and the notion that whistleblowers are just whistleblowing is a concept to keep nice people like ourselves into some sort of framework where we understand that there's a sense of good and bad, which in itself manacles us and limits us in that belief in itself, which is bullshit in the first place, then the libertarians need to think in a much broader perspective.
Sure. If I could perhaps just answer your question. I think, I take your semantic point. When I talk of whistleblowing, I suppose in this context, I just mean people exposing internal wrongdoing, regardless of whether they believe that the agency they work for is inherently bad or not. I mean, I guess inherent in the idea of what I've been calling whistleblowing is the idea of someone internal to an organisation demonstrating wrongdoing from that organisation. It would be rare, I suppose, for a person to remain in an organisation that they view as highly bad in the first place. And so generally, I think most people who do that generally work for organisations whose mission they believe in, at least initially, and perhaps become disillusioned. In Snowden's case, at least, he had been working either directly for or for contractors for the NSA for quite a period of time, most of his adult life, I believe, and had initially a very fond view of the NSA and the American national security state in general, and became disillusioned with that over a period of time, and then ultimately decided to expose some of that wrongdoing as a result. So, I mean, look, I take your semantic point. I think what you're telling me is that you wouldn't call them whistleblowers because you disagree that they should believe that the agency they're working for is good in the first place, yeah?
That's right. And the other thing is the Australian government, you know, like they've accepted the fact that what Edward Snowden said was correct, that, you know, we were doing this stuff to Indonesia in 2009 or whatever. But we've just taken it as accepted for a start, which is terrific in a way that they have, the Australian government. And the Canadian government has taken on board Edward Snowden's thing about the Canadians gave America permission to spy on everybody in the last G20. And it's like, his information comes out as real now. Edward Snowden's like, he has said this, and it's true. And it's really taking on its own narrative in a way.
Sure.
Really
I think, actually, I suppose probably one thing I can perhaps finish on is the idea of the government diverting would-be whistleblowers into channels to diffuse them. The government itself creates, as one of its means of diffusing disillusionment and rebellion by its own employees, states create their own internal complaint mechanisms and attempt to filter disillusioned people into those complaint mechanisms. And the whistleblowers previous to Snowden, there was a guy called William Binney in, I think, 2001, who believed that the NSA was engaging in illegal action along the same lines that Snowden did. He went through these internal complaint mechanisms. I believe he spoke to his seniors in his own agency and also reported the matter to congressional oversight panels. And essentially these kinds of things went nowhere in terms of changing the behaviour that was going on, the wrongdoing that was going on. Ultimately, these other leakers some of them did go public, and I say some of them because the ones that didn't go public we just don't know about, but I'm sure there would have been many. And they went public with claims about the NSA, where Snowden was different from them and more successful than them, and these previous whistleblowers have acknowledged that he did the right thing in where they'd previously failed, is that he had evidence directly from inside the NSA to expose to the public. So it wasn't just a matter of taking his word for it. So I suppose just the concluding point on it is that I think Snowden's success came from the fact that he went outside of government-mandated channels in this, whereas previous whistleblowers did not. So thank you very much, everyone.